It is my pleasure to welcome you to the 6th edition of the Legal Innovation Day, a conference which became the most important event of Wolters Kluwer, and I hope to say the most important event where you can see new ideas, innovation, tools at work, tools that work, or tools that not always work, experiences, actually. This is how a good entrepreneur is, yeah? Making many mistakes, of course. It's mostly our best ideas, our best tools, not only from Romania, but our guests from European Union countries, with whom we share the good, the bad, all the happy of the judicial problems and issues. And I think the first edition was starting with in COVID years, so you can imagine the struggle there, where digitalization just took its first real step, that we had no choice but to do that, unfortunately. So we were very fortunate to have with us different representatives of the bar associations, of the courts, of the professional, and this was all possible just because of our partners, Chiriță și Asociații, Czech Bank, Microsoft, Milcev Burbea și Asus Romania. I want to thank each and every one of them, because without them we would not have the pleasure of seeing all these beautiful things. And now, because the show introductions are the best, we had also this feedback at the first workshop. The ones which were there just gave us this hint: keep it short and simple. I would like now to give the floor to Mr. Dan Oancea, Professor Doctor, Director of the National Institute for Training and Development of Lawyers, INPPA for the Romanian colleagues. Mr. Oancea is the Director of INPPA since 2019, a member of the Permanent Commission of the National Union of Romanian Bar Associations, UNEBR, a member of UNEBR Council since 2007, and a member of the Bucharest Bar Council. He is also a member of the Governing Council of the National Institute for the Training and Development of Lawyers, the Board of Directors of the Union of Jurists of Romania, and the Administrative Council of the European Institute of Romania. He serves as an arbiter at the International Commercial Arbitration Court, attached to the Chamber of Commerce and Industry of Romania, and is the President of the Hearing Commission of the National Anti-Doping Agency. Mr. Professor Oancea, you have the floor. Thank you so much.
Thank you so much for the extensive presentation. However, first of all and above all, I'm a lawyer. And I'm doing that since 1982. It's quite the time has passed, but I'm still young and feel so strong enough to cover my quantum of work and also to participate in these excellent conferences, for which I'm congratulating Wolters Kluwer, not only for the quality of this conference, but also for the steadiness in doing so. I understand that it is already the 6th edition of this conference, and I wish you many more to come. As you know, we have two panels in this afternoon. I have the honor of being designated coordinator of this first panel, which has as a topic AI trends shaping legal professions, which is, of course, one of the big things which we have to deal with, especially in the now when we have huge development in AI and with multiple effects in very many but not limited to the lawyer activity. I may introduce the members and speakers of this first panel. to my left is Mr. Sergiu Stănilă, who is the Vice President of the National Association of the Romanian Bars, and who is in such capacity also responsible for the Department of Judicial Assistance for Legal Aid. He is a lawyer in Timișoara, former Dean of the Bar of Timișoara, and also a professor of the Faculty of Law of the West University of Timișoara. I hope I didn't forget anything. Then we have Mr. Sebastian Naste from the Romanian Cybersecurity Agency. And last but not least, Mr. Adam Iareș, who is also in the same field. He is head of legal and legislative department in the Digital and Information Agency of the Czech Republic. Unfortunately, today the Dean of the Bucharest Bar, Mr. Aurel Ciobanu, will not be present, but the Bucharest Bar will be represented by Mr. Radu Sora, who is already present online and who will take the floor online. As order of speakers, I would suggest to start with Mr. Stănilă, then to give the floor online to Mr. Sora, and thereafter, because they are in the same field of activity, Mr. Naste and Mr. Iareș to speak, and we will English. So I myself will alternate between Romanian and English because we have also to give a break to the translators and to easy a little bit their work.
Just want to say, if anyone needs translation headsets, they are available there in the back. So it's up to you if you want, if you need such headsets.
I will switch very shortly to Romanian. Vreau să mă refer puțin de pe margine ca să zic.
I'd like to express myself sideways as a non-announced speaker. We'll discuss the topic of AI in the legal practice and mainly in the lawyer's practice. I am not among those who are optimistic that the lawyer's profession will have an easy survival in the AI era. On the other hand, it's on the contrary. I can't even say that I'm a temperate optimistic. I'm rather pessimistic because I know in the lawyer's profession, people try to adopt changes quite late in Romania, which means the lawyers aren't very keen on getting adjusted to changes. They're willing to keep doing what they've been doing for years. I mean, the generation with some extent of experience and the elderly professionals. It's not easy to adjust to changes, that's true. It's not easy to shift your activity, the quality of one's work, and the nature itself of your work. Let's be honest about it. Let's admit this means this tool, which is called the artificial intelligence, has its good and bad sides. I discuss about what is less positive about the AI. In this fierce competition between the AI and the profession of lawyers, there's another participant, which is the client. Any traditional client would address lawyers to find what their rights are, according to the law a few years ago. This is not the case anymore. Since digitization has developed, since the internet connectivity has become widely spread, especially and mainly in the rural area, everybody has access to legal information. Clients don't address lawyers anymore to find out what the law provides. Now with the AI, they don't even have this issue anymore. Clients address lawyers with this feeling they know superior knowledge, which give a preferential status to the client faced to the lawyer. Nowadays, clients believe they have their own personal insight, and they hope for price and honor and fee discounts from the lawyer because the client already knows something about the case. The lawyer knows how to classify this very case pertaining to the law case. It's like when you go to the doctor, the anamnesis or diagnosis. The lawyer establishes a diagnosis, but it's more and more frequent that clients get to lawyers while already being aware of a certain diagnosis. Clients establish their own legal diagnosis because they're getting help from the AI. That's a frustrating reality for lawyers, of course. Lawyers realize that the legal classification claimed by the client is wrong or not accurate. The legal grounds are not accurately presented. So simpler work becomes more complicated than in case people didn't use the AI. What happens? This very valuable tool called the AI is fully expanding now. It's in full progress, and the very fathers of the AI cannot anticipate its evolutions. That's a very big question mark. How well, to what extent AI means will evolve in the future? To what extent will criticizable wrong or partial or hallucination disappear someday? The AI currently hallucinates, but there are paying alternatives which are much more accurate than the free of charge versions of the AI, and the error level is much reduced. Since this exists, lawyers need to get ready to be aware that they need to shift their activity. Lawyers need to be aware that to be able to play in a competition against the AI, they need to provide a much more sophisticated product compared to whatever the AI can provide, or compared to what lawyers themselves can provide without the AI. First, lawyers need to master some knowledge that make them able to act as people knowing more than law, people knowing more fields than law itself. Lawyers need to be knowledgeable about other fields such as psychology, sociology, economy, medicine, ethics. There are ethic details involved in a lawyer's profession. Everything mixed together, or everything considered, makes any lawyer an encyclopedia. They need to be more knowledgeable than whatever the codes of law provide. That's why the lawmaker had some intentions when they ruled some laws, and the lawyers need to be aware of all this. So the present-day lawyers need to be able to provide a strategy considering all the pertaining details and the client psychology at the same time. It's difficult for the artificial intelligence to grasp such peculiarities, such features, but a lawyer can grasp a client's psychological traits, and more than the client's family's psychology, because there are inheritance cases which involve several people from the client's family, and the lawyer need to know psychology about it, since those people have contradictory interests, or the client's business partner's psychology if a commercial case arises. Hence, the lawyer's life becomes increasingly difficult. We discussed about the downturns of the legal profession, but this is not necessarily a bad thing because they need to reinvent themselves at some point. That's a useful exercise for them to bring novelty in one's professional life. That's not necessarily a bad thing, but what's certainly positive is that this tool, the AI, is very effective for professionals because it gets their work more professional. Prima facie, it provides some information lawyers need to check first and foremost. The AI provides some idea templates with ideas, be it a procedure deed or written conclusions or legal opinions in the case of consulting lawyers. We can't doubt that this tool is extremely useful. Yet, there is a risk for lawyers to get de-intellectualized, that is, to stop reasoning beyond what the AI provides. And younger, less experienced lawyers often get into this trap. They're happy they can get an easy outcome, saving them hours of research in the library or in the databases. But young lawyers often cannot or do not double-check such information because they're happy to finish earlier. Compared to any other tool, we need to have an ethical attitude compared to the AI as a professional. And I'd like to inform you that starting from 2026, at this Romanian National Institute for Training and Development of Lawyers, we introduced a new subject matter called the ethics of using the AI in the lawyer's profession. That's a new subject matter which was useful starting from this year. What matters to us is not the AI as such, which we need to accept as a tool, but the question is how shall we use it so that will not jeopardize our professional integrity nor the client's interests. It's an entire complex reasoning that we need to consider. I apologize for this introduction. I admit it was quite long, but I really wanted to share a few personal opinions about this topic before starting this panel. And I'll switch to English now to pass the floor to my peers, starting with lawyer Stanila. Thank you, Professor. Thank you, Walter Skluver, for providing me for the second consecutive year the opportunity to attend this high-level partner of Walter Skluver a few years ago. Here's a confirmation of your everyday work. I'll speak in Romanian because I have very technical concepts. Since Professor started this trend of discussing about pessimists and optimists, I'm rather optimistic with respect to using the AI. I'd like to summarize my opinion as an AI tool would do. The optimists are happy because among the many benefits of an AI tool, beyond many other drawbacks, the AI provides us with an antidote to a finite resource, which is time. We'll certainly not try to evolve. Professor said that we can get replaced at some point, but I'm optimistic will not be. Last night I talked to some peers of mine, and a few years ago I was informed about a judge's ruling, judges pronounced in a criminal law with 35 defendants, civil parties, and many other participants. The judge's ruling in first instance has 3,677 pages. My client asked me to require it by mail to get some time, to gain some time. When I start reading more than 3,700 pages, it will take time to get the accusations and everything. Of course, I asked it to be sent by email and not by mail. And I didn't even use AI tools, only Adobe. And I learned my client's name was mentioned more than 700 times in 400 pages. So not even using the AI. I only used Adobe Acrobat, and I was able to identify some words in a very long text. This helps us simplify our activity. So I discussed about it last night with my colleagues. I didn't see the outcomes of using the AI, but I'll share them with you at some point. That's a very recent case. I got the file on Monday, and I'm optimistic that the AI will help us save time. If you ask me about lawyers and the way the lawyer's profession can be exercised in Romania and whether they get adapted to the AI and whether lawyers are responsible for getting adjusted to that, if you ask me whether the profession in Romania gets adapted to the AI, the institutions managing or ruling the lawyer's profession are liable to answer this. I have a few minutes in this panel to tell you about the way the National Bar Association in Romania understood we got to get in line with the AI, and will establish an IT system to provide ex officio legal assistance. Not many of you are not familiarized with that. I mean the cases when criminal but also non-criminal case participants or trial parties cannot afford to pay for a lawyer, and the Romanian state provides an ex officio lawyer for them. There are procedures to appoint this lawyer. The lawyer will be paid from public funds for people who can't afford it. Starting from the 1st of January 2026, the management of ex officio legal assistance in criminal and non-criminal cases will happen in a unitary way throughout the country using an IT platform or exclusively while using AI tools. If we get back in time, the very first signs of AI happened 10 years ago. There was a need there, a need emerged for us to get uniform access to legal specialists, to money provided by the state. And the idea of a random assignment of legal experts occurred 10 years ago, because we wanted to stop favoring some legal experts, because some would be assigned frequently on some positions and others rarely. Many of the bar associations developed their own IT platform, providing a few resources from what we currently can call the AI. Of course, we're now in the case when communicating with the prosecutors' offices and the courts of law happen by fax or by phone call. Communication between lawyers happen by phone, by written texts. which will be replaced by faster, more confidential tools, providing confidentiality of contents as well. Starting from this acknowledgement, the Romanian Bar Association in Romania applied the financial tool to support this unique IT platform in 42 counties of Romania. That's 42 bar associations. This helping the courts of law to get integrated with the judicial system called ECRIS 5. This will start operating from the 1st of January 2026. The communication among bar associations will be much easier and the human factor will disappear. My title, The National System for Assigning Lawyers ex officio at the National Association of Romanian Bars Council, will become an IT tool called e-UNBR, UNBR being the Romanian Bar Association. This process hasn't started, but this will help us be more functional, operate more quickly, and will operate through this hybrid system. Though we discuss about IT platforms, though the latest statistics shows us that 30 of the 42 bar associations deal communication with AI tools, though such tools are not rudimentary but quite at an early stage of the AI, whereas the other bar associations still communicate by paper means. Whenever an IT system exists, people communicate by fax, by email, by phone, and there is no unique flow of communication. There's always a human factor intervening in the operations for the system to be operational. By extending ECRIS 5, we'll get all the bar associations connected at a standardized level nationwidely. All the professionals will have access to the judicial process, and this will get this platform developed. The goal of this project, very briefly, you have them listed on the screen, but the bottom line is to create automatic, very quick flows between those in charge of the legal deed, that is the courts of law, the prosecutor's office, the bar associations, and another goal is to eliminate human factor as much as possible, to eliminate communication by fax and email. As far as the overall data flow is concerned, the courts of justice send a request to designate an ex officio lawyer to the bar association. If we the number of the criminal case and the capacity of those people in the case, a certain number of lawyers are assigned, the fee is established. The Ministry of Justice and the High Court attached to the High Court of Cassation and Justice are informed. This unique platform will automatically identify the geographical area where an ex officio lawyer is required, depending on the location of the court, how far away it is from the prosecutor's office, and they will fill in the report and the lawyers appointing and send all these documents back to the court, the judicial institution, or to the prosecutor's office without the intervention of any human factor. These are the elements to be filled in the request filed in ECRIS 5. The number of file, the procedure identifier, the court of law or the prosecutor's office, the section, the panel of judges, and the other important details. That's what we wish to. Let's see whether it happens. What are the features users of this system, identify the relevant bar association automatically, send the request to the bar association automatically, receive the appointment. The entire IT platform will be established at the expense of the Romanian Bar Association. The maintenance of the platform will be also paid for by the Romanian Bar Association. That means other bar associations will be exempted of the cost for managing the system, but they will not lose the competences providing by this. Such a platform completely gets rid of any documents sent by fax or any phone call. It eliminates sending any summon by mail or manual registry of documents at the file, and this cuts human errors, of course. If we develop other components, the risks will be minimal. Such an IT system based on AI will help the entire legal system. This brings benefits for the beneficiary of the law process, for justice seekers, to provide a complete right for justice seekers to be defended. This is just a component of what the E1BR platform means. This will happen over the next 2 years and will also have professional training. The platform will get the link of the professionals with the judicial system by connecting them to ECRIS 5. Thank you.
Mr. Stanila, I'm giving the floor to Mr. Radu Sora, who is online, and who I am asking if he hears us. Mr. Sora, are you there? Can someone help us? Okay.
I hear you very well.
Thank you so much
Yeah.
for being there. Please be so kind to share with you your thoughts as to the topic of this first panel, Mr. Sora. Thank you.
Yes. Thank you so much. Thank you so much for giving me the floor, Mr. Wancha. Thank you so much, Mr. Stanila, for being so clear about what's happening with the position of the public defender in the future. First of all, I have to thank Walter Skluver for giving me the opportunity to speak on behalf of Bucharest Bar Association to present the Bucharest Bar Association viewpoint. As a person talking about what Mr. Wancha just invited me to say, I can say that I'm not a pessimistic nor optimistic person when talking about digitalization. I'm just realistic because I understand very clearly that in this moment that digitalization, AI, and everything that pertains to that, it is here to stay. And if we will not adapt as a profession, we will have to disappear, because everybody that in the future, in the history, that opposed to what really seemed a wave that comes and it doesn't stop, have disappeared. I'm sure that we are that smart to adapt, and for this reason, you already heard Mr. Stanila, which is the vice president of the National Union of the Romanian Bars, that somehow even the profession of the lawyer's profession is adapting to the digitalization. And now I will go to present my view, but my view somehow filtered by the view of the Bucharest Bar about digitalization. But in order to talk about digitalization at the level of the lawyer's profession, I believe that we must first understand where we are now, to understand what kind of tools we have at our disposal in order to deliver legal services to our clients in the most efficient manner. First, as lawyers, we use for a long time, I really believe that, professional legal document and jurisprudence research platforms such as Syntact from Wolters Kluwer, our esteemed host from today, or time management and invoicing programs or platforms such as LexForce, also from Wolters Kluwer. More recently, we started also to use software as Legal Assist, if you know, which helps us in drafting documents and making reference to laws and cases quoted in the document. So it's not new for us if we are talking about digitalization. If you remember the lawyers that started the profession before the year 2000, we can remember those times when we needed a law, we had to consult a very long list of official gazette of legislative documents on a paper material. That wasn't easy to make a research in those times. Also, most of us remember that started long before 2000, that we started to use communication such as letters. We had a lot of decisions or a lot of requests made by hand or by typing, and we forgot very fast at some point when the mail appeared that the post office exists, because when we started to use emails, nobody really thought about postmen. I just gave an example of how evolution already started long before 2000, and we are still here. Yeah. And when I'm talking about the digitalization in the lawyer's profession, we have to take into consideration, in my opinion, also the level of digitalization of the entities we enter in contact with, which are mainly, for us lawyers, courts of law, fiscal authorities, city halls, National Trade Registry, National Cadastre Office, and many other administrative entities like that. If we can talk bluntly about all these entities, we have to understand also their level of digitalization, their current level. Talking about courts of law, almost all courts have now the electronic file, which is not entirely complete because most of the files are not complete, and still we have to send lawyers to examine files which now cannot be photocopied anymore, or at least this is the case with some courts. But on the other hand, we have, let's say, the very good example of the Court of Appeal from Galați, which for me is an example on how digitalization should be, because not only they have one of the most complete systems, there are many situations when in this jurisdiction the cases are judged via online conferences. And by this means, I salute also the leadership of that Court of Appeal led by Mr. Doru Benescu, which is the president of the court, and which is continuing the work of the former president, Mr. Cosmin Mihail Răzvan. Why I'm telling you this? This Court of Appeal of Galați, in this moment, by trying to digitalize almost everything, I'm saying also about all the files. I understood that there are some equipments that can really scan documents, and they can send the documents to relevant files without the help of a clerk, without the help of a person that scans the documents and they put it on the files. This type of work, I really believe that should be repeated, should be copied by all the courts, and I really believe that the environment, the legal environment will be really improved for everybody, for the people that have cases there and also for lawyers. Think about with the help of a conference that you make instead of a transportation that leads you towards the judge. It's really helping you saving time, saving fuel, and also helping us to breathe a cleaner air by not forcing us to leave a trail of carbon in order to appear in person in front of that court. So I really believe that everything that happens there must be really copied and repeated. About fiscal authorities, while we as lawyers have SPV in Romania or VPS, virtual private space, as individuals or owners of law firms, we do not have a dedicated communication channel where we can really be the representative of our client. So there is so much space to be improved inside this institution. In other words, when we want to represent somebody in front of the fiscal authorities, sometimes they are saying to us, please use the SPV or the virtual private space of the client. We do not have a dedicated space. We are not really taking into consideration as a representative authorized of a client. I really believe this must be improved. This can be changed. And also that kind of innovators about that kind of innovators system that Mr. Stăniră was talking about, it can be somehow implemented as one-stop shop connection that can connect us also with the fiscal authorities, and not only with them. What is the situation with the National Trade Registry? This institution, since the pandemic started, the National Trade Registry went online and made very good steps toward the complete digitalization. Everybody knows that after the pandemic started, the National Trade Registry went online, and even that nobody believed at some point that a document that was notarized or attested by a lawyer could be sent to the trade registry without authentication. Nobody died. Also, the electronic signature appeared, and this made things really easier. Also, when I'm talking about institution, I can say that lawyers never had a special channel of communication. And I really believe this is wrong, as long only professionals authorized to represent clients can give guarantees both to clients and trade registry regarding the documents submitted and the effects that documents would have. So it is also recommended that in the future such a channel to be available. City halls. When we are talking about city halls, the city halls have complete autonomy. But because of that, each city hall has a different way of doing things, from totally analog to almost digitalized in a very unique manner, which sometimes leads to situations very, very odd. For instance, because also Mr. Stăniră gave you an example, we had an example where we sent an email to a city hall and they responded to us that we have to talk to them only by postal service, paper postal service, or via the contul contribuabilului, which is the account of the taxpayer. So basically, we were diminished somehow, and we were somehow denied the possibility to use email in the communication with the city hall, which is really odd. And also, in the communication with the city hall, there is no dedicated possibility for a lawyer to represent a client. You can use the taxpayer account, which most of the time it's a very, very personal account, just like an SPV, and not an account of a representative, which is of an authorized representative, which is the lawyer. So very, very broadly, lawyers are working somehow in an environment which is not completely digitalized, and it's not completely clear and predictable when talking about communication, or when talking about ways of also communication with every entity. For instance, it was brought to my attention, and somehow Mr. Stanila already emphasized that to us, that even that an electronic file exists, the lawyers, in the moment of the communication of a decision, they request the decision to be communicated via postal services. Reasons are multiple. In the case of Mr. Stanina, it was very clear that the reason it was the volume, the extraordinary volume of the documents. But on the other hand, I remember that we started to use very fast scanners from 2010, when we had cases just very comparable to Mr. Stanila case, where we had to browse through thousands of pages from arbitration cases. And the solution was a very fast scanner. Usually 1,000 pages can be done with a very fast scanner in less than 400 seconds. And that scanner, the result of that scan should be a searchable PDF. Just like Mr. Stanila said, with Adobe, they solved the problem, because the searchable PDF, it can enable you to search inside that document that you have to examine. Okay, so basically, what I want to say is that we really believe that as lawyers, we need to have digitalization, but this should be clearly not in conflict with the privilege of confidentiality. And since 2023, when we had a project about digitalization, which was in fact a project of interconnection between lawyers and other entities, we didn't have something similar. In that moment, the problem of the lawyers was that the whole document, the whole case of a lawyer about a client, it was compulsory to be uploaded in a system that was entirely controlled by a foreign entity. And in our opinion, most of the lawyers thought that this kind of system would impede with the right of defense and their confidentiality privilege. In the end, I can tell you that the challenges in this profession are resistance to technology. Some legal professionals are, not only lawyers, are reluctant to accepting technology in our profession. virtual world or cloud storage are not giving efficient legal environment, transparency for the client. So basically, these are the opportunities that lawyers have in this moment. And when talking about risks, we can say that the biggest risk can be the over-reliance on AI assisted drafting, and also the erosion of confidentiality through digital tools. And the most important is the potential dehumanization of the lawyer-client relationship. In the end, we can ask ourselves one thing: what are we trying to achieve? We want clearly to protect our profession while we become more efficient. But how can we do it? I think only time will tell us, but we must remember one thing: the decision of a judge or a deal, comprising also the negotiation of a deal, must be and will remain a humane process. Surely, the AI and digitalization will help them in the process. And in the end, yes, maybe AI will take jobs for humans from lawyers, but only for lawyers or humans that will fail to adapt. So the only solution to what is happening right now is to adapt to digitalization and to embrace it. Thank you for your attention.
Thank you too, Mr. Sora. Thank you for your very interesting considerations for the practical aspects related to thereto, and also for the sound conclusions of your speech. You mentioned several times the platform for the judicial assistance referred to by Mr. Stanila. And I can tell you, because I remember now, while you were speaking, that Mr. Stanila and I paid a visit to Sofia in Bulgaria, and they use a very elaborated, sophisticated platform for allocating cases within the legal aid system. And for instance, they feed in this system, including the personal relation between judges and lawyers. So, for instance, if a case is allocated to a certain judge, automatically the system will not elect the husband or the wife who is a lawyer of that, the lawyer who is a husband or wife of that judge. This is an example of how digitalization can really help and efficiently help in that regard. This is only one example. Time is running, so I will further give the floor to Sebastian Dan Naste, who will speak about the dual role of artificial intelligence in cybersecurity, both as a powerful ally and as an emerging source of sophisticated threats. You have the floor, Mr. Naste.
Thank you very much. Good afternoon, everyone. I'm very aware that together with Adam we are staying between you and the coffee break, but then I will try to be as brief as possible. And indeed, we are talking about digitalization, we are talking about artificial intelligence, and we are talking about transforming some legal professions. So my intervention today will touch upon a little bit the cybersecurity risks that might arise when using and when relying on AI. But first, I would like to introduce the entity that I represent here, which is the Romanian National Cybersecurity Directorate. The clicker doesn't work, so maybe if you could jump. It has a okay. So if we can move, I mean, you can. Yeah, it's working. Yeah. Thanks a lot. So yeah, I will start talking about what do we represent? So basically, the National Cybersecurity Directorate is the main national authority that is responsible for cybersecurity in Romania, that is dealing with the civil cybersecurity space. As you can see on the right hand, there are different authorities that approved our existence, that we've been through transformations, and since 2021, and we became the National Cybersecurity Directorate. The main mission is to ensure the cybersecurity of the national cyberspace in collaboration with all competent authorities and relevant actors. And the main vision, the Directorate aims to become an international class institution that firmly positions Romania as a recognized leader in cybersecurity. As you can see, we do not operate alone. There is a whole bunch of ecosystem which is very complex, and we work in a very dynamic and deeply integrated across different national and international authorities, because we function and we must function as a part of strategic network and interconnected stakeholders working in close coordination with national leadership, including the Supreme Council of the National Defense, the Prime Minister, the government, and we work within the Prime Minister office and basically the Secretary General of Government with the General Secretary of the government. I will not insist on this. We'll share later the presentation with you. We have entered actually a phase of expansion, and we have an ambition target to reach and to expand and to reach 1,000 staff members by 2030. Because this growth does not only reflect the complexity of the cyber threat landscape, but also the broadening mandate that the Directorate received in 2021. And as you can see, there are different categories where different people could sit in, from strategy to regulatory affairs and control, institutional partnerships, expertise and projects, and many more. And open for business is not just a slogan that we like to use, it's more like the Directorate's readiness to work side by side the private sector, academia, and public institutions and international partners to deal with cybersecurity. A little bit more about the Cyber Hub role. As you can see, we focus on different parts, on business. We work together with academia, with the research experts. We work together with other government authorities, but also with international partners and allies, because this is also important for us to become a regional cybersecurity hub here in this part of Europe, having Russia at the borders. The Directorate's collaborative approach, of course, we do a lot of regulatory affairs, because we ensure that Romanian cybersecurity legal framework is not only robust, but is also harmonized with the EU legislation. My colleagues deal with the implementation of NIS2 directive and future implementation of future regulations such as the Cyber Resilience Act and the Cyber Solidarity Act, and many more. We also do a lot of education, prevention, awareness and training. We have different training programs. We participate in many EU international projects and programs, and we also develop and implement cybersecurity strategies and policies that are relevant for the stakeholders, as the one that I just mentioned, the NIS2 directive. I will not insist on those key roles and responsibilities. You can find them in the emergency ordinance if you are curious, but of course we do a lot of cooperation, alerting, prevention. We also do the ensuring the compliance in for different entities that must comply with the NIS2 directive, and so on and so forth. But I would like to talk today about AI and its dual role in cybersecurity, because I would like to ask you a question. Would you see more AI like a friend, like a colleague that is helping you to complete your tasks, that is helping you to comply with your deadlines, to do better? Or do you see AI more like someone that could steal your data, someone that could use all the personal data that you are putting there, the professional secrecy that we were discussing about. Who would go that AI is more like on the friendly side and it's really helping you to become better? You could raise your hands. Okay, okay. And who would vote that AI is more like a bad person that is trying, to say that is better than you in doing your work and is stealing your data just to become better and to sabotage you along the way? Okay, we have one gentleman there, 2 persons. Okay. Yeah. Okay. We can also have in between. Indeed, I mean, this is all about AI because AI brings new challenges for cybersecurity, but also for its use, because there are multiple ways where AI can be used. We are living in an era where AI is not just something utopic, right? AI is here since 1980, I guess. There were a bunch of professors that they closed the doors in the Stanford universities. They had some nice whiskeys and some cigars, and they just invented the AI, and then some computers came up, the definition of AI came up, which is still not universally accepted. So, as you can see on the screen, there are some defining characteristics of what could be the AI. For example, information processing to collecting and interpreting data, or decision making based on reasoning and learning with the goal of performing specific tasks, but also the AI must have autonomy in carrying out actions. I heard here on the scene that in some processes that you guys are doing, you still have the human in the loop, which is great because that person can actually think and can actually, oversight the authority of just of a program that would decide that some person, might be guilty, or some lawyer might be that the best fit for the person to be represented. But in a nutshell, we could say that AI systems are generally software solutions which are developed either through machine learning or logic and knowledge-based methods. And in addition, for a set of human-defined objectives, they can generate outputs such as content, such as predictions, such as recommendations, decisions that influence the environments they interact with. Some examples of AI and their uses in cyber defense. As you just said, you received more than 2,000 pages of a case. In real life, when we analyze a lot of data about a cyber attack, there is vast amounts of data in real time, and AI could help us to revolutionize cybersecurity because they can help us to detect anomalies, to predict potential attacks before they even happen, but also from automating threat hunting processes to enriching information streams with real-life time insights. For example, by tracking threat actor profiles and cyber attacks across regions and industries, AI predictive models can analyze different data sets. They can analyze the indicators of the compromises and of the techniques used so that a nation could stay protected for future similar cyber attacks. And then we have the machine learning, which is by far the most popular branch of the AI. We all heard about machine learning, but also we all heard about LLMs, such as GPT and Sora and other LLMs that you guys are using in your day-to-day activities, which are just, processing a lot of data and making an output without thinking what they are saying. From here, the hallucinations that the professor was talking a little bit earlier. Other relevant, interesting examples of how AI can be used in cyber defense. They can be used in spam detection. So not all the spam emails that you guys receive, like buying new towels from that entity, or buying new products from other companies that we all receive on our personal email addresses, and nowadays also on the business email addresses. They may be stopped with the use of the AI. But also malware and intrusion detection, because installing an AI cybersecurity product on your premises can enable you to analyze the key characteristics that would indicate the presence of the malware but also some machine learned based intrusion detection solutions that might recognize DDoS attacks and ransomware attacks and other attacks. And I would like to share with you an interesting example of an AI product which is called Google Cloud Armor, which recently, a few weeks ago, blocked the largest DDoS attacks in the history. So basically, a DDoS attack is an attack that we send multiple solicitations to one computer. So let's say we log into your website, to the union of the bars, and then we send multiple, like millions of requests of logging in, and then the site eventually will stop working because it's like going and trying to shop something for Black Friday. That's flooding, but that's not on purpose attack, but that's flooding, you know, with information and with trying to access that website. So about the DDoS attack works more or less the same, because its main aim is to stop you to access your service that usually is, let's say, normally accessible. And then the solution provided by Google stopped 398 million requests per second. That's a lot. That's a lot. And to put that into perspective, just to understand how much that volume of data is, this volume equals the entire month of Wikipedia traffic processed. So during 1 month, when we go to Wikipedia and we check something, this was the amount of data that was sent to different websites just to put them down. But also, the AI could also help you to optimize and to work in different SOCs. Some companies have a security operations center, which is kind of a war room with techies, with geeks that will stay in front of computers and will try to protect your company or your entity. But also, there are AI-powered attacks, which are becoming more and more sophisticated. There are threat actors which are using AI, such as Meta's Llama AI. I don't know if you guys tried it, or ChatGPT. There are cases where kids, 8 years old, 9 years old, they just use ChatGPT to launch cyber attacks and to create different softwares to launch cyber attacks. And we can say that the AI amplifies those cyber threats. We have deepfakes. We have real cases that happened somewhere in Singapore, where a senior employee was tricked to transfer 25 million during a video conference with his colleagues, which was on Teams, but his colleagues were not real, and his colleagues was basically generated by AI. And the case was so real, and the voices and everything, they operated a next level deepfake that the employee went to work after this meeting. It was an early meeting in the morning, and then he met with his director. He said, "I did that transaction. I'm very happy because you are happy." "What transaction are you talking about?" "The one that we just discussed like 1 hour ago in meeting." "What meeting?" "I was playing golf with my colleagues. We were all there." "Oh, okay, I got tricked, and then I just transferred 25 million to an entity, to a group of cyber criminals." And this is what's happening, because a ransomware attacker and other attackers could have endless opportunities with the use of AI, and that's why, together with my colleagues in the directorate, we developed a different exercise. But now, because of the time, we will not play it together. I will share this presentation with you. You can do the exercise, and I'm very curious. Let me know via email how many points you got out of 10. There are 10 pictures and videos that you can analyze, that you can see, and then just try to go along them and identify which is the deep one, the fake one, and which would be the authentic one. But also, we have developed some cybersecurity awareness materials, because it's part of our jobs that we are doing. We have a guide for protecting social media accounts, which is available in 3 languages, Romanian, English, and Ukrainian, and also deepfake guides, manipulated or informed. This is for the moment just in Romanian only, so feel free to download them, to have a look. I will not insist on this one. Just to wrap up, why the AI also needs protection, because the AI has to be protected. because there could be different vulnerabilities in open source software libraries. We can manipulate the training data used for the use of AI. There could also be attacks that will change your data, so basically changing your input. So for example, if you develop a database with some criminal cases, there could be some attacks that would change the data, maybe the personal numeric number of that person, maybe the previous years that the person got convicted in a way or another. So this kind of data could be manipulated. So the result at the end of the results that would pop out using an AI chatbot might be different, having real data there. There are a lot of AI cyber threats. I will not insist on them, but the one that I like the most is the fact that the reverse engineering of trained model. This type of attack uses publicly accessible queries that we are doing on ChatGPT, on other softwares, and they involve techniques such as model theft, model inversion, or membership interference attacks. So basically, as I said, they could change the output of the command that you give in the chat in ChatGPT or in other programs that you guys are using. Just to go a little bit on the high-risk AI systems, maybe some of you heard that this AI Act will be postponed, at least parts of them will be postponed to December 2027. So basically it's more than 1 year after the original date, which was August 2026. And this, the AI Act, I know that you are all lawyers or you read already the AI Act, I will not insist on that. But actually they did this derogation especially for the high-risk AI systems, and also which contain the obligation to assess the cybersecurity risks. I not insist on the what is an AI risk application. I can give you an example. So let's say that we have an AI Act that might control some elevators in a building. That could be an AI risk because that could pose a risk to the person, or an AI risk, high-level AI risk could be one that is a lot of personal data, a lot of, let's say, sensitive data, and the output might have a direct effect on that person. Do not have a human in the loop. But of course, there are some limitations of the AI model as well, and I invite you to read the definition in this EU Act. Some conclusions. If I'm pessimistic or optimistic, I think I would be somewhere in between, because AI plays a crucial role in cybersecurity, but still can be exploited by different malicious actors. Europe did great because they introduced an EU robust framework that regulates AI systems, and I think that many other countries are following. So I think that we have the so-called GDPR effect, that many other countries adopted GDPR after the EU proposed the GDPR. We see the GDPR in Argentina, in some in some states, in the US, in APAC region. So I guess the same will happen with the EU AI Act. Of course, there are some challenges in securing the AI systems because it's just a software in the end, and you cannot say in cybersecurity that you're 100% protected, like never. There are opportunities that are brought by AI for strengthening cybersecurity, so for helping us to be more cybersecure, maybe more cyber awareness inside the different entities and companies. But also, I heard the word ethics, and indeed, ethics is really important in collaborating and working and developing AI new softwares. But I would also urge for the need for ongoing recent innovation, because it's as someone just mentioned here yesterday, also during the dinner, if the Roman law has around 2,000 years, we are just writing the history of the digital law and digital economy law. If you have some questions, I don't have any answers, go straight and ask ChatGPT. I'm joking, we can continue the discussion at the coffee break, and sorry for being a little bit over time. Thank you very much.
Thank you too for this extensive list of risks and threats I can't refrain from asking what happened the day before yesterday, because hundreds of websites stopped working, including ours, and if I'm not wrong, your department's website as well.
So indeed, the Cloudflare didn't work. So basically, Cloudflare offers protection for DDoS attacks, as I just mentioned. So Cloudflare works as a barrier to stop different unsolicited accessing different websites. And I saw in the news that a lot of websites were down across the world. So this is what can happen to technology.
It wasn't only in Romania.
No, it was it was globally. It was globally, if I'm not mistaken.
I see Mr. Jaresh nodding, so I assume the same happened
in Czech Republic as well. You know, I produced a podcast and some other stuff around it, and I was like without hands because I want to produce some like picture and graphics in Canva, and it didn't work. So I wanted to use ChatGPT and didn't work. So I want to complain about it at Twitter, but it didn't work. So.
Can you imagine the level of originality that part of the world had without being able to use ChatGPT in writing decisions or legal documents?
Thank you again. So, Mr. Jaresh, you already took the floor. Please continue with your consideration as regards user-friendly and transparent public services with artificial intelligence.
Thank you. First of all, I need to thank the lady over there in the booth translating. You are doing a great job. Thank you for the translation. I really appreciate it. And also, thanks for having me here. I'm really delighted to be here between such an esteemed speakers and also in a room full of such skilled professionals. I really liked the speeches that were held before mine, because I'm glad that I could hear about the perception of artificial intelligence by lawyers or cybersecurity experts in Romania, and that I mean, we are on the same page, I think. I'm not also that optimistic, but not that pessimistic. And I'm not sure if you guys know the term Luddites. Luddites were the guys in England in the 19th century that they decided that they would destroy some machines because they were scared that the machines would take their jobs. And sometimes, if I talk to other law professionals, sometimes it seems like they are Luddites as well. Honestly, AI could take our jobs. I think AI could honestly take our jobs, but I believe that providing legal advices and running a law business is a relationship business, and we sell trust. So I believe that AI can steal our jobs, but only from those who remain just only lawyers, as Professor Oeska said, and I completely agree. Because, I mean, we need to understand that we need to become something more than just lawyers. We need to understand our clients' needs and provide something more than AI tool can provide. Can be also, we can give advices on such, on more topics than just law, and I think sometimes clients just need to talk to somebody who's not just an AI tool. All right, so let's dive to my presentation. All right. I'm trying to press it, but it doesn't work, I guess.
Cyber attack.
Oh, yeah, definitely. Yeah, I need to apologize to ChatGPT and Canva and Cloudflare. All right, let's dive to it. You see, we in Czech Republic, we love mottos. We used to be Czech Republic, the country for the future. If you come to Czech Republic as a tourist, you will come to Czechia, the land of stories. And nowadays, we are trying to be Czech Republic to top 10 in AI, as our government representative for AI states like maybe every day. And in my presentation, I will cover some topics regarding use of AI in public services and let you decide if we are the land of stories or if we are a country for the future or if we deserve to be in top 10 in AI. So I will cover these topics. I will cover how does ideal public administration looks like from my point of view. I will cover what has been done in Czech Republic and what should be done in the future. But first, let me do a brief introduction. The Digital Information Agency is central government authority for electronic identification, trust services, and public sector information systems. We are also the coordinator of public digital services, and we fulfill a coordinating role for information technologies. I work at the agency as a head of legal and legislative department. I also spent a couple of years working for Wolters Kluwer in the past, so I'm really glad that I can speak in Wolters Kluwer event outside of Czech Republic, and I also teach sometimes at law universities, and as I mentioned before, I produce a podcast about law and technology. So, how does ideal public administration look like? I believe that public administration should be effective. It should be user-friendly, or let's say citizens-friendly, so it can help citizens to fulfill their rights or obligation. It must simplify its processes and, as I said, be effective. And it also needs to help public servants like I am to do our jobs better. The public administration should also operate transparently and be predictable. And most important thing, at least in my point of view, is that it should take care of its data. Because, ideal government, from my point of view, makes data-driven or data-informed decisions, not just a decision performed like opening a window and look out of the window and say, we can like vote for this because I feel like it today, you know. And my question is if AI can help to achieve such a vision. I believe so, but it's like a circle because the AI systems need to comply with the points I mentioned before. It needs to be secure, so the state can take care of its data and then make data-driven decisions. It needs to be transparent and predictable for the citizens, and it also needs to help us to do our job better. And I will dive to what has been done in Czech Republic this year or the year before. But we will go a little bit farther to the history, and we'll go to the year 2019, when our Ministry of Interior published a public administration development strategy, where the ministry states that the result of the high potential of the use of AI in public administration may be the release of human resources from these jobs in the future, optimally for more creative activities. I'm looking forward to be released to more creative activities, but it hasn't happened yet. And I'm not sure if other colleagues or some of my colleagues share the same opinion. And also, Ministry of Interior states that those people needs to be willing to learn new capabilities, which is not always the case in Czech public administration. And it also states that the public administration has not yet approached this area very proactively. I think it has changed. It was the year 2019, and I believe that it has changed since then. I mentioned our representative of the government for the artificial intelligence. It's a new position that was established in May this year, and the first representative was appointed. His name is Jan Kavalírek, and he's doing a great job ever since he was established or appointed, or even before he was appointed. We also have in our legislative procedure the Draft Adaptation Act for implementing AI Act to our legal system. And we, as a digital information agency, we put together a catalog of AI use cases in public sector. You can take a look. It's in Czech, but if you use Google Chrome or some other browser, it can be translated in English. And I will try to cover a few of AI use cases in Czech public sector and in a judicial system. And let me state that the cases or the examples were chosen just arbitrarily. There's no pattern in it. It was just these are just use cases that I wanted to mention because I like them. First one, and I like it most, it's a chatbot called Adam. I like it obviously because its name, and I think it solves the problem that you mentioned before, because it helps employees of the Ministry of Finance in audits of subsidies and grants, which is work where you need to go through like thousands of pages of documents, and it's not, I think it's not fun and it's not easy. So the chatbot can help these employees to do so. And I mean, if I heard your story about a judicial ruling with 3,000 pages, it's kind of a horror story. I think it should be illegal to write a ruling that's longer than 20 pages. We also have in Czech Republic, actually, we have some judicial decisions that says that parties and their representatives should write shorter submissions to the court. So I think we need to also be telling to the courts that they should write shorter rulings, because it's like it goes both ways. And I don't know if you know our former president, Václav Havel, who died in 2011, and he's well known for like promoting democratic values. So there were a chatbot called DG Havel developed, and it helps to study democratic values in the private school. And I would like to mention our project, which is prefilling forms with AI, because if you communicate with Czech public administration, you most of the time communicate through some kind of forms. And those forms are pre-filled with data that state already knows about you, for example, from public registries or from information system of the government body. but you need to sometimes fill also other data that the state doesn't know, and this tool should help you to do it without errors, and like to guide you through the process and in general. And our Ministry of Defense and Military Intelligence also are developing an AI tool against cyber threats. It's something like you mentioned. It should help to spot real-time cyber attacks and like to predict what will happen while analyzing network traffic, some encrypted data, and using artificial intelligence tools and some tools around it. I believe that is a crucial tool, or it's crucial to use AI in cybersecurity, because otherwise we can like close our computers, go home, and never come back to our offices, regardless the sector. It's not just a public sector, it's the private sector as well, and I think public sector even more than a public sector. And what's happening in the judiciary system? To be honest, not much. We do have the Center for Digitalization and Artificial Intelligence in Justice, which was founded in spring this year, and it also got an AI award in an AI competition that happened like maybe 3 weeks ago. The guy on the picture, he is vice president for the High Court in Prague, and the center focuses mainly on educating judges and other court personnel. And my question is it enough? Is the center enough? I said that not much is happening in field of justice in Czech Republic, but I believe it's enough. It's enough now, because I strongly believe that we need to educate justice personnel first. We need to understand how the system works, how we can deal with deep fakes, and how the evidence can be fraud. So I guess for now it's enough. It's even more important than developing our own AI tool or some AI model for judges. We need to, as I said, first educate them. And we need to educate, all of us need to educate, mainly in a public sector. All right, I will just briefly, I know that I'm the one standing before the coffee. I'm the last one who's preventing you for having a coffee, so I will what should be done briefly. We do have in our legislative procedure the draft for amendment of our administrative procedure code, which kind of opens doors for AI to an administrative proceedings. It states that if the nature of the matter or the protection of the rights of affected persons or the protection of public interest does not require that the act in the proceedings should be carried out by an official person, such an act may be performed automatically without participation of the official. There are some exceptions. It cannot be used if the matter concerns decision on an appeal, or if it requires the use of administrative discretion. It means that it can be used in cases where the judge sorry, it's not the judge, where the official can decide, for example, about the type of penalty or how high the fine will be. So it can be used mainly or maybe just in like simple proceedings, but it's a good start, I would guess. It also states that such an act doesn't have to be signed by an official if it guarantees the integrity and origin of the data. The proposal is in the legislative procedure, as I said, but to be honest, the legislative procedure ended by the end of the previous election period, because we held an election months ago, and we will see how the new government will approach this matter. And I would like to mention last two things which I deem to be important. I visited a digital summit of Polish presidency in Gdańsk in spring, and I heard two very interesting presentation by Krzysztof Chtowski, who's a Ministry for Digitalization in Poland, and Hanna Verkunen, who's the Vice President of European Commission, and both of them stated the need of digital sovereignty in Europe, mainly concerning the AI tools, meaning that we shouldn't rely just on AI tools that are made in third countries, because to be honest, in my point of view, are like a huge corporations, and if they decide they don't want to comply with European law, they just wouldn't. You know, if we take into account the example of Meta Ireland, who needs, of course, such a social network needs to have a representation in the European Union. They are based in Ireland, and they are fined big time. Last few years, they've been getting like huge fees. And what happened? They are just predicting those fees in their budgets for next year. So if such a corporation decides not to be comply, they probably won't. In Poland, they are developing their own AI LLM model based on Polish language, which could be the way. And both of them also mentioned the necessity of building AI gigafactories in European Union, something between 4 or 6 AI gigafactories, which should do mainly two things. It should produce chips for an AI system, and produce computing power for European AI systems. And also, one of them will probably be in Czech Republic, which, if it happens, I would deem as a great success for Czech Republic. And coffee. Thank you.
Thank you so much, Mr. Jaresh. I was impressed by the examples you gave relating to how AI can be used for the benefit of the citizen, and can only hope that our public authorities will have an exchange of good practices with your authorities. I was very optimistic when I asked our host at the beginning of our panel if we have time for questions and answers. So obviously we have not any more time. We exceeded already the allocated time frame. I would suggest to our host that if you have any questions, please direct them to Wolters Kluwer, and we will receive them via Wolters Kluwer, and we'll do our best to respond to your questions. Thank you once again to all the speakers. Thank you once again to our host, our gracious and host. I am sorry for exceeding 15 minutes the allocated time. I hope we will not kill your coffee break by that, and we thank you for your attention.
Rugămintea mea mare este, dacă se poate, să fim la și jumate înapoi, pentru că doi dintre speakerii din panelul următor trebuie să plece spre aeroport, să prindă avionul și știți ce înseamnă traficul greu.
We will explore how AI is not just a tool for legal professionals, but also a test for our frameworks of responsibility and ethics. And I couldn't think of a better lineup of experts today to guide us through this conversation. And with this warm-up introduction, I would like to present the first speaker today, Oana Chiriță. She's a founding partner at Chiriță și Asociații and heads the firm's non-criminal litigation and counseling practice. She's an expert in commercial and IT law, EU labor law, and very relevant to our topic today, AI, legal issues and liability. The presentation that Oana will have for today tackles a fundamental question: AI liability in the current legislative framework, clarity or confusion. Please join me in welcoming Oana today, and let's see at the end of this presentation if we'll be more clear or more confused about AI. Thank you, Oana.
Thank you very much. I think I'll need the clicker for my presentation. If you can pass the clicker. Thank you. Thank you. So first of all, little something about myself, just 2 words, because everyone I think is in a hurry. I've been providing legal consultancy for IT companies for about 15 years. In this respect, my need to study AI was somehow organic. And afterwards, it became I became sort of obsessed with learning everything that I could about AI. I started taking courses, some better than others. If you want, I can recommend some, and I can tell you which ones I didn't find interesting or helpful. And of course, given my formation as a lawyer, the main issue which I found was indeed an issue with AI was how can you hold someone liable in case AI is involved? And in this respect, I'm not talking here about liability as in fines for the company, because all of us who have read the AI Act or anything about the AI Act know the fact that in case companies do not comply with the AI Act, with their obligations under the AI Act, they are liable for certain fines. But the main issue which I found really challenging was to find out if a person, if something happens to a person, suffers some prejudice, how can that person claim damages from the entity, from the legal entity who was responsible for using or misusing, should I say, the AI. And in this respect, actually I think I did not use ChatGPT nor Copilot nor any AI agent to draft. I just used main PowerPoint, and I think the writing is a little bit small. But as I was saying, I would not go at this point into details about the EU AI Act, but however, I want to, so in order to frame a little bit my presentation, I just want to say something, that the EU legislature initially focused on hard law and afterwards on soft law. And initially they drafted, so they tried to legiferate the liability for AI, which they quickly came to the conclusion that they cannot do due to the fact that in each of the member states in the EU, the regime, the liability regime is different. So you know, some states have strict liability, such as Germany, and other states such as Romania, such as ourselves, have fault-based liability. And it was extremely hard to unify all the regimes in the member states. And so they went from hard law to soft law. And this is how they passed the horizontal law, which is the AI Act, which initially, which actually focuses on ex-ante obligations of legal entities which produce or which deploy AI. When I'm saying that, so when they drafted this horizontal legislation, the EU AI Act, they based their entire structure on the theory of risk. And this is how they developed, so they said that the AI is necessary. There's no There's no stating the fact, so no one can deny the fact that it's one, very useful, and a, necessary for progression. However, due to the fact that it can cause really great harm for persons, for physical persons, it is mandatory to establish this system of risk. And this is how they establish the fact that we can discuss about prohibited practices, about high-risk AI systems, and afterwards, given the large use of the general AI models, such as ChatGPT and Copilot and Gemini and so on, this category were left outside of the risk system. And of course, we have low-risk AI systems, which currently are not necessarily subject to the EU AI Act because they do not pose any threats. However, given the fact that, so as I was saying, it's clear the fact that their physical persons can suffer extreme harms from the use of AI. And if you just Google, you don't need to use the ChatGPT to ask him. You just have to Google to see that the fact that there have been the famous accidents with the self-driven cars who kill pedestrians, or the fact that there is AI used in surgical robotics and or in putting a diagnosis, and they can put a wrong diagnosis in some instances. Or there are the horror cases, in my opinion, of people committing suicide after talking to chatbots who convinced them to commit suicide. And I was just reading about a court case which is currently pending in the UK, where a teenager, a 14-year-old teenager, used character AI, which is, you can search and you can enter character AI. He was feeling lonely. And he was a fan of Game of Thrones. And he entered into a conversation with an AI chatbot who looked and acted like Daenerys Targaryen. And Daenerys convinced him that he was very lonely and that his place was not in this reality, in this realm, but maybe he can end his life here and enter to another realm, and that there he will be happier. Thus, guess what happened? He unfortunately committed suicide. So the question is, who is liable for this? Because if you enter the terms and conditions on character AI, there's a huge disclaimer stating the fact that character AI will not be liable for any damage caused to people who take as real what are being told by chatbots, first of all. And second of all, the same terms and conditions state the fact that if you are a user based in Europe, I don't know why they chose the age of 16, but you declare that you are above the age of 16. So is this disclaimer valid? Obviously it's not, at least for criminal liability. So going further a bit to the context of liability, obviously the types of liability that can be attracted by the use of AI are criminal liability, with the examples that I just gave them, are contractual liability. Unfortunately, you cannot see in my presentations, but I think it will be forwarded. I linked the standard AI contractual clauses that have been adopted as a recommendation. They are not mandatory, but they are very useful in case you work with companies, and they are structural AI, they are standard contractual AI clauses meant for both high-risk systems and low-risk systems. So in case you're a company, so you are dealing with AI software between two companies, there are this set of clauses that you can insert based on the type of AI system which you are using. And there's the tort liability, or the main civil liability, which is commonly extremely debated throughout the European Union. Why? Because, as I said initially, before the EU AI Act, the European legislature tried to state some harmonized norms for civil liability. They unfortunately could not do that. They tried to pass the AI liability directive, which was at the beginning of 2025 withdrawn, because the member states, as well as the large companies, did not agree with this AI liability directive due to the fact that it did not respond to the various regimes in the member states. And what they did, what they managed to do, they managed to adjust the former product liability directive. So the acronyms over there, the PLD stands for Product Liability Directive, and the AILD stands for Artificial Intelligence Liability Directive. In the Product Liability Directive, so in the PLD to be short, they included software as a product, which is a first step, which is actually very, very important. Why? Because the PLD is a more strict base liability, which means that if in case you are talking about the software and that software causes certain types of damages, then you can claim the PLD, you can make a claim based on the PLD, and the burden of proof will be much, much easier than if you were to go to a national regime and have to prove facts such as intent and causation. However, the PLD is not currently sufficient. Why? Because the PLD covers some types of damages which come from a defect. But we cannot always say that the malfunction of an AI is a defect. In cases, in most famous, in common medical cases, let's say, if the AI makes a recommendation, which is not the best, but it's not a defect, that cannot be, it does not fall under the definition of defect under the PLD. So what do you do in that case? That's the first issue. The second issue is the fact that you cannot claim any type of damages under the PLD. And in this respect, there is at this moment the main issue: should the EU adopt a harmonized framework for the AI civil liability, or should it not? Obviously, there are the huge companies are against adopting this harmonized legislation, and there are others which state the fact that it would not be necessary. Why would it not be necessary, and what is the current status? So in present, if you have a person who suffers a damage of an AI caused or presumably caused by an AI, what happens? The person can go to its national state and claim the EU AI Act or any other type of European legislation, and the court case would be brought before the national courts in that state, who would have to judge and analyze the case by the procedural rules and the liability system in that member state. So in case you were to have a case of AI liability in Romania, you would obviously have to prove all the fault or all the elements and conditions of our fault-based liability system. If you were to go to Germany, that would be much easier. Also, Germany has adopted in 2021 legislation on the topic of self-driven cars. And currently, on October 10th, Italy was the first state in the EU who adopted a legislation on EU liability, which apparently upset the EU legislator, which does not agree with each member state having a separate regime, because it states that it caused fragmentation, and that the same situation will be ruled differently in each member state. And so they argue a whole lot that we need harmonized legislation. But the AILD was retracted, as I said. So currently I found I'll just skip over this. I found a European perspective, a proposal on adopting a harmonized legislation passed by the JURI committee, which is a committee in the parliament, in the European Parliament, which I'll try to summarize it. I also linked it in my presentation. I think it's a little bit further. No, actually it's not. It's a little bit here. In essence, so the main issue is that what they are saying is the following. They are saying that, I think it's somewhere here. Yes, the last one, the AI and civil liability, a European perspective. What the EU Parliament is saying, what the JURI Committee is saying is the following thing, that we should have a harmonized legislation which should be strict-based liability for all AI. So they are really pushing for the strict EU liability due to the lack of need to prove intent and causation. And who should be held liable? They are trying to say that both producers and deployers of AI systems should be held liable and should have joint liability. So they are trying to instate a system of strict liability and joint liability of all legal entities in the chain, so that a victim can claim damages from anyone that was involved in the AI, in the production or deployment of the AI system, which is actually, I strongly doubt, so I will leave to you to assess whether you find this a solution or not. I would strongly doubt the fact that companies will have any courage in deploying AI systems in this respect, because when you are talking about joint liability, I mean, come on, someone who uses ChatGPT, let's say, will be liable to the same extent that someone who produces ChatGPT. So we cannot, in my opinion, this can really impose some main strains on any company who wishes to develop and to deploy AI throughout the EU. But again, hopefully you can, hopefully if you are interested and you will read this perspective, you will form an opinion yourself. So unfortunately, I'm running out of time.
Yeah, thank you, Anna. I would like to ask you a question, and if you can provide a short answer, because indeed we are running out of time. So given the EU evolving AI Act and its interplay with existing liabilities regimes, where do you see the biggest gray areas in assigning responsibility?
I think the biggest gray areas was, as I said, the fact that there is no one single regime. So the main issue is that you have one problem which can be solved in one way in Germany, in another way in Romania, in another way in the Czech Republic, in another way in the Netherlands, and so on. So the fact that we do not have, we have different systems, legal systems in each of the member states, can lead, and we do not have horizontal legislation, can lead to the fact that we can have different solutions. This is one main issue. The second main issue, in my opinion, when we speak about the judicial system, is that, as I was saying, if you were to solve a problem in the national courts, let's face it, at least in Romania, I am pretty sure the fact that the national courts are not ready to handle any AI cases. So we have judges who will be faced with different claims because people will make claims of several damages caused by AI and do not have training. So I think that this would be one main focus, would be to train judges to solve cases, to help them solve cases according to the existing legislation. Another issue which was actually quite popular amongst the legal practitioners was for the European Commission to pass a kind of guides for judges to ensure the fact that the AI cases were ruled upon in a similar manner. I strongly doubt the fact that maybe this could work. However, they are guides, so they are not mandatory. They are mere recommendations. And in this respect, I believe that there can be judges who will say, I'll abide and I can use these recommendations, and others who will say, and this is actually very common in Romania, who will say that no one is telling me how to rule in my court.
Thank you very much, Oana. Usually, I would like in this kind of interactive discussions to give the floor also to my colleagues in the panel, but due to the time constraints, I will wish Oana have a good flight, and thank you very much for today. I hope it was a very good presentation also.
Thank you very much. Sorry it was so short. Thank you.
Okay. Now, I would like to move to the second speaker in the panel, who will offer us a practical side of the AI adoption. The second speaker of the panel is Hineke Wiggers. She's joining us from Wolters-Kluwer, Netherlands. Welcome. She holds both an LLM and a PhD in legal information retrieval. And she's been leading innovation for a decade, helping lawyers using AI to make their work more efficient and intuitive. Her talk today is titled AI Discovery in the Benelux, Lessons for Customer Adoption. Please welcome Hineke Wiggers for the discussion. Thank you, Hineke.
Thank you. And I want to apologize to my fellow panelists and the audience. I also have a flight to catch, so I need to leave in a little bit. But I'm very excited to talk to you about what we've learned so far from implementing AI with Wolters-Kluwer in the Benelux, so Belgium, Netherlands. We're not really in Luxembourg, but we still call it Benelux. So I indeed went to law school. I never practiced outside of an internship. I rolled into legal publishing and then legal tech, and I loved it. So then I did a PhD in information retrieval, and now I have a role. It's officially Senior Technology Product Manager. It's very formal, but basically what it means is that I help translate user needs into technical requirements, and vice versa. I try to explain how the technology works to legal professionals. So today I want to give you a quick introduction in what this product is exactly, and then I want to discuss what we learned both from a technical perspective and from a user perspective, and then a quick sneak peek in what comes next, or what we're working on now. AI discovery is what we like to call retrieval augmented generation, and that means that when a user types in a question, we make a nice vector out of it. That's a machine readable format of the question, and with that we retrieve relevant documents. Then the question and the documents are sent to a large language model along with the prompt we constructed. And that large language model generates an answer based only on the documents that we provided. And that is one of the techniques that is used by us, but also by many other companies to reduce hallucinations. This is what it looks like. There's a nice standard UX page that stands for user experience. And the user can start a conversation by asking a question. Behind the screen, the system does what I just explained, and the user gets returned an answer with sources and can choose to either open those sources and validate the answer, or ask a follow-up question if necessary. When you get an answer, this is what it approximately looks like. I collated 2 pages because it wouldn't fit on the screen, but you get an answer in a structured format, and then in the bottom, the blue links guide you to the sources that the answer is based on. 2 features we learned very quickly that users were very excited about was conversation history. So that's now available on the left side of the screen. So if you later want to refer back to an answer that you generated, or the sources that comes from, to double check that it's correct, you can find it back in the system on your screen. Another one was that customers asked to not only use Wolters-Kluwer content for the answer generation, but also public sources. So all the laws and case law that are available through the government. And you can turn those on and off with a toggle at the bottom of the screen. It helps to make that separation. Some questions are best answered by literature, but others are best answered by case law, so you can toggle it to suit your needs. So that's what the product looks like. These are some lessons we learned from a technical perspective. As I mentioned, my background is in information retrieval. That used to be keywords, and then you generate a document list. Now, I'm very happy to say that users are finally typing more than 2 keywords, which is a real change for IR specialists. I do find that often users still don't provide enough information to find the right documents and just generate the right answer the first time. So the system has to ask counter questions to really get to the heart of the matter. And one of the things we notice is that often the user will type in facts and expect us to know what the legal issue is, but the facts can mean different legal issues. So it really helps if they type that along, or if they type the law area that they're looking in. So we're training users to be a little bit more explicit, but we're also training the system to ask those questions to really guide the user to the right information. We heard earlier today that there are sometimes hallucination problems. One of the things we noticed is that the ECLI numbers were sometimes incorrect. It would read multiple ECLIs in the document, and then it would attribute the wrong information to the wrong ECLI. So the ECLI exists, ECLI was in the document, but it just matched the wrong interpretation to the wrong case. So what we now do before we return the answer to the user, we check if the answer contains any ECLIs, and if so, if those ECLIs are indeed correct, which is one of the techniques we use to limit the amount of hallucinations. What we also learned from a technical perspective, and what I find really interesting, is that existing evaluation metrics do not correspond to user satisfaction. A lot of emphasis was focused on making sure that the content is correct. So every fact that was stated in the answer, we had to check whether that indeed came from the documents. We spend a lot of time on that. There is a framework for that we could use very well, but it turned out that the user cares about more than just facts. So that if we got a higher score on that, it did not necessarily translate to higher user satisfaction. And we dove into the literature, tried to find a evaluation framework which takes all of those factors into account, and thus accurately, I would almost say, predict user satisfaction before we turn a product live. That is not yet in existence as far as we know. So we really need to rely on users, actual legal professionals, to test the system with us before it goes into production, before it's shipped to consumers. So that's a really important lesson to anyone. Make sure that the systems are tested with actual users before you rely on it. The lessons learned from users. Adoption is quite slow. And I think that relates to what was also said in the previous panel, that legal professionals are not very quick to adopt a system that they don't know if they can trust. So they want to verify everything, and then in turn, the verification takes a lot of time, meaning that there's not enough time saved for them to find it valuable. So that's one of the things we also took into account to make it easy and fast to check the reliability of the answer for them to use it. One thing that I noticed in the logs, and which I find funny because I remember it from law school, is that they experiment with questions that they know the answer to, and that they also know the document that contains the answer. So they ask questions about very famous cases from Dutch legal history, and they expect that exact answer with that exact document. And they don't always get it, because that's not entirely how the system works. They will still get the right answer, but it might not contain that exact document, because it might have find a document that references that document and has an explanation of the document and bases the answer on that instead of the original source. Of course, from a legal point of view, I do understand you want to have that right reference to write in your article or proceedings. So that's one of the things that we're now working on, to gather as much examples of questions, answers, and that key document that they expect, so that we can retrain the retrieval part to actually pick up those documents and base the answer on that document. And of course, as my fellow panelists just discussed, there's a lot still unclear about liability, so they don't know how much they can trust on it. There was also just a mismatch of expectations. From a technical perspective, for me, it's clear that retrieval augmented generation is not a search engine. For users, it was not. Retrieval augmented generation returns an answer with sources, but it does not generate a results list. So if you ask it for all relevant case law regarding a certain topic, it will return you some, but it will not be exhaustive. We're working on it to create a separate feature that will do it, because we see that the users expect it, so we just go along with their expectations. But that does require a different piece of technology, so we just have to switch and adapt and include that. The system can draft simple documents like emails, memos, but not complex procedural documents. And you do see people try. There's simply a character limit, so it can't make documents longer than a specific number of characters, but people still try. And one of the things people try, I don't know how much they expect it actually does it, is predict outcome of cases. It only has documents from the past, of course, because they have been published. So it cannot predict what's going to happen in the future. Things we've already adapted. We found out that users like to receive output in the form of tables. We did not expect that. We expected just text. But some users found out by themselves that if they ask for the output in a table, the system will actually provide it. So we adapted that, and we now made it a feature into the product. What we also noticed and did not expect was that users ask for translations of the answers to send to clients across the border. So in the Netherlands, there's a lot of cross-border traffic with Germany and Belgium. So they continually ask, okay, this memo is very nice, can you make it German so I can send it to my client? That was not something we anticipated, but we updated the prompt to make sure that this is possible. And that also ties into what's next, agentic workflow. The retrieval augmented generation was a picture a lot easier than this picture. What we're now doing is adding different modules. So the document drafting will become a separate module, so that when we see that that's the intent of the user in asking the question, we can pass it along to the right agent or tool who can then take from there, and that is highly specialized in that particular task. What we can also do for really complex question, break the question up in sub-questions, retrieve for each specific sub-question, and then generate a comprehensive answer for that. Translation is another example of what will become an agent that was highly specific to that. And the benefit of that is you can also then choose the large language model that is best in that particular task, because they all have specific niches that they're good in. Some are better at Dutch than others. So that can play a role in choosing which model you choose for that specific task. I think that concludes my presentation. I'm strictly on time, which as a Dutch person I always love. So, thank you.
Thank you, Heineke, both for the fact that you were very sharp and in time, and also for the very interesting information that you offered to all of us. Definitely, once lawyers trust AI tools, they actually become more strategic and creative, because the heavy analytical load is reduced. But definitely also this trust must be earned and not imposed. Usually adoption is often less about technology and more about mindset. And I would like to ask you, Hineke, how do you balance the need for explainability with the commercial pressure for speed and automation in legal research?
That is a very good question. I think explainability is very, very important. And one of the things that's been researched recently is whether you can add an additional layer on top of the retrieval augmented generation or agentic workflow that is specifically tasked with explaining what is going on. So there's both a UI, user interface aspect, making visible what's going on so that the user understands and gets that trust. But there's also specific models that can help explain what the system did without having to explain the entire technical process. So it's a nice guided tool that can really help with user trust.
Thank you very much. Okay, now we turn to the intersection of law, AI, and cybersecurity. And our next expert, Mr. Dan Gavojdea, leads cybersecurity and AI security at Fortinet. With over 20 years of experience across global tech companies, including Microsoft, Cisco, Vodafone, Dan is at the forefront of helping organizations turn compliance into true protection. His presentation of today is titled From Legal Obligation to Real Protection, NIS2 with Fortinet SecOps. And please join me in welcoming Dan for his presentation today. Dan, please.
Thank you very much. First of all, I would like to thank the organizers for this event, and thanks to you for the resilience of staying until the end of the event. Hopefully you will get a lot of value from it. I've got a lot of value already. A very interesting panel previously, and also the previous speakers have been touching, I think, the main issues we are considering now in NIS2 context, and not only. Now, I'm an engineer. I'll talk about cybersecurity and why this is relevant for lawyers and legal departments. And I don't have a presentation. I would like more to invite you to a dialogue. And I'll start with asking you something related to a misunderstanding in the market, as much as I am talking with customers, in terms of what level of complexity and difficulty is bringing NIS2 in terms of technical measures. You all know that NIS2 involves technical measures and non-technical measures. Let's keep the discussion on the technical side. I'm not a lawyer. And I would like to ask you, what is the perception you have in terms of the complexity, the level of advancement in additional technical measures that NIS2 impose? Because there are people who consider, for instance, this is like a, let's say, average minimum level of technical measures. There are others considering this is a huge investment, potentially very difficult to implement. And please raise your hands who consider NIS2 as a very complex and advanced set of measures. All right, I think it's half of the room. This is what we see in the market, but the reality, ladies and gentlemen, is that NIS2 is actually the minimum level of security for the resilience that EU is in need, considering the hybrid world we have nowadays. So, starting with the basics, what cybersecurity and technical measures involved in the NIS2 context is basically, you know, very well-known triad of CIA: confidentiality, integrity, and availability. This is what we want to do with cybersecurity, and this actually involves pretty much everything what we need in terms of resilience, because at the end of the day, what European Union wants to have is resilience in, down to every country level, down to every company level, down to every organization level, and this is starting with us. First of all, as users in the company that we are employed, but secondly, as citizens, because we all contribute to this level of resilience. And one of the questions that I like to ask my customers whenever I'm meeting them, mainly discussing with the IT department or security departments, CIO, Chief Technical Operations, and so on, it's what can happen wrong, or what is the top wrong incident that can happen in the organization. Because starting with this question, you'll go straight to what is to be protected first, or where is actually the most vulnerable layer. And I can tell you from tens of years of experience in cybersecurity that users are the weakest link in an organization. Please raise your hands who haven't put anything confidential or close to PII data into ChatGPT or any other LLM. Right? Okay, congratulations. The users are not doing that, so we cannot rely on users keeping the policies and security. It needs to be embedded. I was fortunate to work for Microsoft. Happy to see Gabriela Popescu here, and I can tell you that without advanced or very advanced solutions, it's impossible actually to keep the users, outside of the policy. I'll give you an example. When I was a Microsoft employee, there are certain advanced solutions like Microsoft Purview security that is actually stopping the user to put inside an LLM, including the own LLM of the company, considering that you have developed one, any confidential information, PII data or anything that is actually, by policy treated like that. So all of us, we need to understand that technology is technology is critical actually, and is having a place in a NIS2, and starting with the initial conversation we had on NIS2, I wanted to touch base the year of 2026, because we have a representative from DNSC here in the room, and we all know that in 2026 we are going to see the first fines, penalties to companies that are not going to align to NIS2 requirements. And once again, NIS2 is the minimum level of measures that we should implement. Now, what is also not very well understood in organizations, I think that the legal department have a very important role, is to touch base the board and the CXO, let's say, level of people, in order to make them understand they are directly liable if an incident or an event is happening, or a big downtime that is going to to affect the company operations. And this is not understood very well at this moment in time. And I think, again, the legal department is not only the one who needs to make them conscious about it, but also to demonstrate that investment in technical measures. I am representing a cybersecurity company, and I can tell you that there is an entire portfolio, and over that portfolio of technical measures that you can implement, of course, up to the risk appetite of the board to consider the minimum requirements or to go over that. Most of the customers are going to align to the minimum level of requirements. However, considering that the CEO is directly liable, that should change the mindset of NIS2 as a checkmark obligation, but having NIS2 as a guidance for the long-term investment of the company in what we call resilience. And one thing that is going to happen on top is not only that the company needs to take care about its own organization, but we are talking about supply chain management, meaning that organizations need to assess their suppliers if they have a certain level of compliance to NIS2, especially if they are in critical infrastructure or they are you know, certain entities, as the NSHA is mentioning, like it's critical infrastructure and essential and important, actually, the two levels. I would like also to touch base a little bit to misconceptions in AI, meaning that most of the companies nowadays are considering AI as a top potential risk. It is a risk, but it can become an advantage for most of the organization. You all heard today, even in the workshops or in the panels, how many operations can be improved by using AI. So we can also say that AI is not going to be a risk, but is going to be a competitive advantage on top on improving the operations of the company, but in a secure way. What does it mean, secure way? It means that you need and you should have the capabilities, and we are talking about technical measures here, to audit, control, and monitor everything what is happening from the user to the LLM and back. And it's not an easy journey to align with certain technical measures, but it's like a mandatory, I would say, critical step for the organizations to do if they want to become competitive in the market. Because you either use AI today, or someone will substitute the company or the person who is not adopting it. In my opinion, early adopters will be the future advisors, and this will be for sure very important advantage. Last but not least, I would like to discuss a little bit about how, because we are in a legal Innovation Day event, how legal can become part of the teamwork of with the board and with IT and security in order to transform this tension to intention, intention of improve, of course, and to resilience. And one of the best practice is the Cyber Resilience Committee that is organized in organizations together with legal, the board, IT, and security all together, like in a team that is meeting with a certain, with a recurring meeting in between them in order to answer to certain questions like what is next to be done. Because what we do as a security company for our customers, we are helping them to map the vulnerabilities and to have a technical plan in terms of measures that are prioritizing them in the way that the companies needs to have in order to reach the compliance. Because compliance is not like, okay, we implement this, and that, and we are compliant. Actually, it is going to be an ongoing journey, and a clear agenda in terms of what is missing, what does it, how much does it cost, how much budget do we need. It's critical, but also the role of the legal department, in my opinion, is critical in order to transform this need and mandatory acting in implementing certain measures, either technical or non-technical, can be translated to the board in competitive advantages. Because this is most of the problem, this is in most of the organizations that we are having discussions about NIS2, they are considering NIS2 as another investment they need to make, like an additional tax. But it's not like that. It may be a competitive advantage that can be demonstrated like an ROI investment in their future resilience, as well as in their future competitive marketing advantage that can be communicated to the market. Last but not least, I would like to emphasize that, of course, budget is in most of the cases one of the barriers for many companies in order to do the steps for this resilience level, even at the minimum one. And you heard today as well, but you need to know that there are certain ways of investing even without the budget, meaning there are certain programs and investment programs like PNRR, like Digital EU, as well as non-refundable programs that the government and EU is offering, as well as support from the vendors, like you know, SOC as a service, Security Operations Center as a service. You pay a fee, because not all the companies will have the resources, not only the budget, but the people, you know, the competencies and the skills in order to do the right management of this vulnerability and risk related to NIS2 compliance. But the vendors can offer this as a service, as a subscription, either as an, you know, there is also an option to externalize the service for security and measures, technical measures, but also bringing them inside as a service. And last but not least, think on cybersecurity like a continuous audit that can work 24/7 for companies in order to identify as soon as possible vulnerabilities or incidents in order to be able to report it back to the NSC, not to take a fine out of it, but in order for everyone to learn from what is happening near to us. Because nowadays, and I'm talking from the recent example, one of the critical infrastructure in electricity in Romania, an energy provider, suffered an incident, and the others were not able to learn from that because there is not a platform of communication in between. Now, with NIS2, I think the NSC will have a beautiful tool from where we can all learn. Yes, the NSC is going to support us as much as they can from this, as much as we discussed. So, consider Fortinet as a partner for technical measures, and either with technologies on-prem, but also up to cloud. We are a cloud provider through the Azure services from Microsoft. All our services can be consumed by through the Microsoft Cloud as well. So we are very flexible in order to support these measurements. Sorry for being 1 minute in extra talk. Thank you very much again for having me.
Thank you very much, Dan. You've really draw us the line between what's legal compliance and what's genuine resilience. And I think it's clear for everybody that security today is not just about an IT topic. It's part of our corporate governance. And for lawyers, it's about building trust frameworks, not just risk frameworks. And definitely NIS2 is making the shift from ticking the boxes for compliance, as you very well said, Dan, but embedding cybersecurity into corporate governance. The integration between legal frameworks and AI-driven security is becoming a defining line between reactive and resilient organizations, as very well Dan said. Now, Dan, if you will be so kind, I have also curiosity. How do you see from your perspective NIS2 reshaping the legal and operational responsibility of organizations in the next period?
As much as I discuss with lawyers that I know, it is most probably that the legal department will have an additional responsibility on NIS2, because we need, considering the amount of organizations that they will be in need to be compliant with NIS2, there are over 14,000. Consider that in NIS1 there were like 3,500 or something like that. Now we have 15,000. From where we can take the those people and this special role in order to understand technical, legal, operational, all together in one person. We don't have this amount of specialists. So I firmly believe that legal department will have a critical role, not necessarily to become responsible of NIS2, if not like that, but will have a active role in supporting the board in order to connect actually all the dots in the organizations. Because at the end of the day, we are talking about a potential liability and fee that the company needs to pay for an incident. And by the way, there is no company that is 100% protected. It's not going to be like that. From now on, sky is the limit in terms of what can happen. And in my opinion, if the light can be stopped on the globe, I think this is because this will be because of cyber incident globally. But I don't want to go into the dramatic mode. I would like to take this as a constructive way of the discussion, meaning that the legal department is potentially the project manager of NIS2 in an organization, not necessarily responsible directly, because it should be like a NIS2 responsible, like a DPO today. But until companies will have these people, I think the board will rely on legal department, not only to fix the dots and to make the communication smooth in between, but also to drive the board to the right direction, including allocating the budget, reviewing the measurements that have been implemented, and support the board in order to understand further level of protection and resilience they need to reach. Yeah.
Thank you very much. Thank you very much, Dan, for the answer and for your view on that. And I would like now to introduce the next speaker of our panel, Gabriela Popescu. She is the country manager of Microsoft Romania and Moldova, and having accumulated almost 30 years of experience with several multinational companies. She's a graduate of Faculty of Law of Bucharest University and holds an MBA at the University of Washington, being recognized as one of the strongest counsels in the local market by the Legal 500 GEC Power List for Central and Eastern Europe. By the way, we have a meeting tonight with them. Yes. Yeah. Okay. Gabriela, thank you for joining us. And let's hear together what Gabriela will tell us about AI for legal professionals.
Thank you very much, Ciprian. Thank you for dear organizers for inviting me here, and thank you the distinguished co-panelists for your speeches, which are very interesting. I promise to fit in the 15 minutes. It's already late in the afternoon, and everyone is probably tired. I'm actually here with two hats. The one as being a lawyer, so talking about AI from the lawyer perspective, and also talking about AI from Microsoft perspective as one of the main producer of artificial intelligence in this moment in the world. And I have a few slides, very few slides, and some videos with demos, because images and videos speak more than words, so allow me to start and see if technology works, helps us. Okay.
I think that our industry has to have a common vision. It was a time that connected us to incredible things. My name for this vision is information at your fingertips. And 3 decades later, we find ourselves in a new era. One where access to information becomes access
There were a lot of very powerful messages in this video, which I like a lot. But for the discussion that we have today, I would like to stay with one comment that was made, one very important statement that was made in this video. This is that this new generation of AI is for everyone, everywhere. And I chose this particular quote because it is a very strong one, but I think it's a very strong and can be very challenging one in a community of lawyers. And we are today in a community of legal professionals, respected and very skilled legal professionals. And having such a statement can be challenging and can, I'm sure, lead to a lot of discussions. We do not have time for these discussions today, but I would like to discuss about, to develop this a bit with you in this community of lawyers. Because it is not only about AI, it's about how we use AI, what kind of AI we are using, where do we take it from. Because like technology in general, especially artificial intelligence, can be, as our president say, a tool, but it can also be a weapon. And Dan was talking about security, was talking about principles, was talking about how do we rely on AI, what kind of systems we have behind, what is the security behind, what kind of connections can our employees make from the company structure systems. And this is a discussion that is even more important in our community here, because in some of the companies, or in all of the companies that you work, when your company intends to do some digitalization, wants to buy a new product, an AI product, most probably will come to you and will ask you, dear lawyer, dear legal department, can I buy it? Is it safe? Which is the risk? What am I exposing the company if I'm including this artificial intelligence tool in my in the company? And this is why it's very important to understand what kind of tools you are buying and what is the provider giving you. Is it a responsible AI? Do you have principles behind? Where are these principles included? I'm working for Microsoft, so I'm going to tell you that Microsoft is committing in the contracts, not only in nice videos that we are making very nice videos, but all the commitments that we are making, and I have another slide talking about a few of them, are included in the contracts. You can find all of this online, they are public, not necessarily the easiest contracts, I might admit, but the commitments that we are making are included, because this is the way that we are committing to everyone that is using our products that we are serious about what we are doing. When GDPR was invented, and I'm using this word intentionally, a few years ago, Microsoft was the first company that committed through the contract that Microsoft technology will protect you consumers, will have the data protected as per the GDPR requirements wherever they are stored or processed in any moment of the contract, and we are the first company that including this in the contract. Why? Because we believe and we trust that AI should be done, technology should be done in a responsible way. What about Romania? And again, I included this slide here intentionally because we are a community of lawyers, and I have discussed with way too many representatives of different institutions who told me I cannot go to cloud because it's not legal. Well, not only that cloud is legal, but we are one of the few countries in the region that have a cloud-first policy. For most of the countries, a cloud-first policy law is aspirational. We have one. It's just up to us to use it. This law says that whenever an institution starts the digitalization process, the first approach that the institution should take would be to go to cloud, and only if there are reasons behind that can be explained, we are using on-prem. So we have a law, cloud is not illegal, AI, it's not illegal. Of course, we have to understand whom do we contract and which are the rules and commitments that the company does for us. So as a representative of one of the companies that is producing AI and has a history, a very long history in AI actually, I'm recommending that you have open-mind approach. You understand that cloud and AI are not illegal, but when you are buying or approving something, you are checking. You have to know and you trust your cloud, your provider. What kind of commitment are included in this contract? I mean, I can promise you whatever, but how do I make this promise? It's just that I'm looking in your eyes and I ask you to trust me? No, you have to look in the contract. Are these commitments in the contract? Where are my data allocated and processed? Of course, depending on how sophisticated your cloud provider is, this can be more or less important, but not many companies, not many providers are committing for EU to store and process the data within EU. Microsoft is one of them, and you have this in the contract. How will I be protected by a cloud supplier in case of litigations? And we had discussion earlier about hallucination. Even people hallucinate sometimes, then AI is doing this even more. But if something that I'm taking with the help of AI, it's hurting me, I'm using information and these are not correct, what am I going to do? What is happening to me? Microsoft has a copyright commitment that it's included in the contract. What does it say? It says that if you are using an information that you received using the AI tool of Microsoft, which is called Copilot, and someone is suing you for that, Microsoft will represent you in court and will pay for all court expenses if someone challenges you for information that you get through AI. Are all the tools I use integrated? Because this is very important. We are talking about the different AI tools that everyone is using, and we are a legal professional community here. Have you ever asked yourself what is happening with the data and your secret professional, your professional secrecy, when you are using some of these tools? I can tell you that most of these tools, all the information that you put there are going in the internet, and the smart guys that know how to use this can retrieve from the internet the information you put there and can impersonate you. And we had a session done for HR community, and it was someone from a bank who said, oh my God, but I have actually asked today that specific AI tool to help me with some advices from the law for a dismissal that I have. And my colleague, who is much smarter than I am and very technical, was able to impersonate the person, to get all the information from internet and show her that basically what she put there was could be found. And last but not least, why do we keep talking about AI? What the fuss about AI? Does it help me? And I'm going to show you two demos, because again, images do more than words, on how AI, especially in our case Copilot, which is an integrated tool in Microsoft 365, helps you. Oh, sorry. No, I missed one. I missed one. I'm going back. I'm going back one more time. Here. No. De ce nu mă lasă să... Okay, let's do this one.
When they wish that they can turn their proposal into a custom-ready presentation without having to start from scratch. Now you can. Using just your own words, Copilot can translate Word into PowerPoint. Now you have a professional-looking presentation that you can hone and polish. Let's say you want to add a slide. Give Copilot some quick instructions and it immediately generates it for you. There it goes. Copilot doesn't always get everything right, so it's important to verify you're happy with it and make any edits that are needed. So this slide is too wordy. You can ask Copilot to make it more visual, which it does effortlessly. And check this out. Copilot can even animate a slide. It gives it a professional design treatment in a single clip. But it doesn't stop there. Copilot automatically generates speaker notes for all your slides. It's not only a time saver, it's helping you be a better presenter.
I missed the word one because this was the one that I first wanted to show you as legal professionals. No, it's not working. Okay, it's working.
With Copilot in Word, you have an invaluable partner working on your side, helping you become a better writer. You will now be able to seamlessly integrate Word data directly into your document. Let's use an example where you need to respond to an article. To get started, you ask Copilot to reference the latest product specs and mirror the approved format previously used. You had a great meeting on the customer's needs, so you ask Copilot to fill in details
Fascinating, isn't it? Okay, so I have 1 more minute. One more thing to say about Copilot. As I told you, this is the artificial intelligence tool that it's embedded. It's part of Microsoft Office 365. It is an integrated tool with everything that you have, meaning with your Outlook, with your Teams. Hopefully you are using it with Words, with PowerPoint, with your cloud archive. So whenever, and it has 2 tabs. One is work and one is web. If you are doing the work tab, it uses all the information that you have from your, you know, in your archive, everything that you used, and you can ask, for example, to do you a summary of emails received from a specific person at the tasks that you received during the last days. And then if you want to prepare for a presentation and you need information from outside, then you press the web tab and it gets you information about, I don't know, something. So it's an integrated system. It's an integrated tool. It benefits of everything you have, and most importantly, it offers you all the security and the guarantees and the commitment that Microsoft gives you. So don't be afraid to use cloud and AI. Just make sure that you know and you trust your provider in your cloud. Thank you.
Thank you very much, Gabriela, for the very, very interesting presentation. It's good to find out that some instruments that you have with very, very easy access, but sometimes you are not using the full characteristics of the instruments that you already have on your desk, and you are looking for some sophisticated solutions while you are having very simple and easy to access instruments exactly on your desk. Thank you very much. I have also one curiosity, and please let me know your view based on your experience. What do you think from your perspective are the key barriers the lawyers are facing when they want to integrate cloud or AI? Is it about trust? Is it about usability? Is it about cultural resistance? What do you think from your perspective?
With the disclaimer that what I'm sharing doesn't necessarily happen only in Romania. It happens in some other countries. It's a combination of things. It's first fear of taking a decision and making a recommendation, who comes from a misconception. I would also say it comes from, and I'm using a strong word, and I don't want to use the word in a bad way, but it's about information, it's about being educated, and it's not an easy field to learn about. It's about the fear of making a recommendation that might fire back. We call them, and I think this is the right word, perception barriers. There are perception. We are dealing with perception mostly, not with real facts, and we do not have enough information or that much information or that many people to go and address this perception barrier. But if you go and you look at what is the reality, of course you have to understand which are the risks. Let's talk about, you are in FSI, let's talk about the National Bank of Romania, which is the regulator. When a bank wants to go to cloud, the National Bank will not say go or not go. The National Bank would want to see that the specific bank understands the risk and has a mitigation plan. This is what the National Bank, in very simple words, does when a bank wants to go to cloud. So this is about also taking or not taking a decision. It's about making sure that you understand the risks and you are making an advice, doing a mitigation and understanding. What I would like to say, and I said this yesterday in an event and last week in an event, while we are debating, and it's wonderful that we are debating, and it's what we should do to debate and to understand, digitalization and AI are happening. They are not stopping. And they are happening, unfortunately, faster in other countries than they are happening in Romania. In Romania, adoption of AI, the percentage of adoption is 15.3%, the lowest in the whole Europe. Everyone else is moving faster, and this put us in a bad spot. We are losing competitive advantage, and we have the right legal environment. We have huge talent in Romania. We have many people that know technology, but we are still dealing with these perception blockers and fear to take decisions. We need a bit of more strategy, and as I said, while we are discussing about this, and it's great that we are discussing, others are moving faster and we are losing competitive advantage, unfortunately. Thank you.
Thank you very much, Gabriela, for sharing your view on this. And thank you again for your presentation. It was really an eye-opener for me, and thank you very much. Now,
one more comment, sorry. So you saw here the demos that were done by Copilot. Copilot is part of Microsoft Office, Microsoft 365. You need a license. But we also have Copilot Chat, which is free on the internet, and which provides almost the same thing, and which also protects you because your data are not going and feeding internet. They cannot be found. So I recommend, I'm sure that everyone, almost everyone is using other means, AI tools. Go and try Copilot Chat and see how this can help in your work. Sorry, I interrupted you.
Thank you very much. We'll move now to the fifth speaker of our panel, Cristina Teică is a seasoned content strategist and legal publishing expert, currently acting as content manager at Wolters Kluwer, Romania. With a strong background in legal content development and editorial coordination, Cristina plays an important role for bridging the gap between legal expertise and technological innovation, ensuring that professionals have access to accurate, timely, and actionable information. And she will lead us through her presentation today, Lex Expert AI Solution from Poland. Thank you very much, Cristina, for joining the panel. You have exactly 2 minutes.
2 minutes, quick and short. Nice words, isn't it, about me? They are made up with Copilot. Because I never been into a panel, I had to make something up to sound good. It doesn't lie. I am all those things, but maybe in a simple words. I am not a lawyer. I am not an IT guy. I am just a former law student, 25 years ago. I never practiced. And I ended up in this IT, let's say IT firm, where I learned many, many things. But today it's not about me. It's about Lex Expert AI from Poland. I drew the short stick in presenting this thing with many, many emotions. You know, all know Syntact.ro, I presume. It's the Polish platform has a generative AI included on that platform. Let's start with big no-nos. We all know about some misfortunate guys with that used AI and they got fined. A guy from California paid a lot of money because he used AI and generated a lot of false codes. And a Big Four firm had to refund some money to the Australian government because also they used improperly the AI. Our goal here is to prevent this from happening to you. Going forward, I could bore you with some technical presentations, but I am not a tech girl, so I won't. I will leave it to the tech guys. And I'll go forward with a short presentation, what is Lex Expert AI and what is not. It's a modern solution that uses generative AI and a selected database. In this case, is the Polish database. It allows you to use natural language and provides answers based on relevant legal documents. It helps you interpreting regulations, seeking legal information, and analyzing it. It is not a search tool. It helps you to get updated information and to analyzing it. Sorry. They selected some content, and that is official documents as our official monitor, decision as in our jurisprudence, and official addresses, we do not have that. And some authors' works, Q&A, articles, commentaries, practical commentaries, and case notes. On speed, priority is given to the most new documents pentru a minimiza erorilor. Cer scuze. Trebuie să învățăm și despre prompturi. Îmi cer scuze, o să trec în română, cred că o să fie mai bine așa pentru toată lumea.
Apologize. I'll switch to Romanian because I'm very nervous and I'm not used to speaking into English. Why are the prompts good? Because they help us get what we want in natural language that we would all use in a conversation with our peers. For lawyers, it's important for us to be able to ask some things from our colleagues. When we'll ask for a contract, they'll tell us for what purpose, and from whom we need to ask things. That's how we need to talk with the AI, to provide the background, not to use abbreviations, and to provide as many background information so that the AI can have such an accurate response. The presentation is in English. It says precisely what I said earlier. It's important for you not to introduce sensitive data in AIs, as Gabriela said earlier, such as business secrets, personal data. It's very important not to introduce such sensitive data in AIs, in AI tools, and it's important to check the source. I've got a few examples of questions. What some properly worded prompts should sound like, because I've got a live presentation on the platform. We can use those questions to see what answers we get, or we can invent some questions ourselves. Security, because security was mentioned earlier. The AI tool is not used to train other AI models. Data is not transferred to public AI models. The servers are located in the European Union. Personal data is processed according to the Lex policy. The Polish company's policy. When we'll adopt this model, we'll of course follow the GDPR rules. This is even more technical. It is a SOC 2 certified solution, which means my technical colleagues may help you. I checked myself. SOC 2 is a security auditing tool. It ensures the privacy of the tool. Do you know what SOC 2 is? It is a standard to certify the safety level in a company. You put it very properly. What are the benefits of Lex Expert AI? We have quick access to relevant legal information. It checks sources and the accuracy of their answers. It helps interpreting to interpret the norms. And the content is strictly selected because it really relies on accurate databases, on reliable databases. It's safe. It's like setup.ro, except that it has one additional button. It's an AI assistant called Lex Expert AI. It will look like the presentation of our colleague from Benelux, except that it's precisely product-oriented. It's got a prompt. Can you see it? Then I can type my question below. Do you have any example of a question? What taxes on salaries are there in Poland, for instance, if I may consider to move there? It takes a while for it to think. It replied in Polish, of course. But technology helps us, and we can translate the answer. It makes a summary about the remuneration. It replies my strict question that this information is provided for in the labor code. It tells me about how it happened, and the sources are quoted in the end, which I can use myself. I can open and check the sources myself. It's a very early stage. The Polish colleagues launched this model yesterday. We are lagging behind because we're the younger brothers, not necessarily poorer, but younger, and Romania will follow the Polish example in the future. We really wish to implement this model, this AI model ourselves. It will happen in 2026. I can't guarantee whether it's at the beginning or at the end, but 2026 is a fair expectation. I've got a question for you. My name is Wana. I'm an associated partner at a law firm with less than 50 lawyers. What contractual guarantees will you give that the AI will not be trained with the data provided? So how can you guarantee that your AI model will not be trained with our data, and that this piece of information will certainly not be disclosed to other parties? How can you guarantee that? I think we can guarantee this by using the contract that you conclude with us, a contract in which we undertake that your data will not be disclosed outwardly, and we don't even store it. I admit I present the solution to my colleagues from Poland, and I'm not ready to answer from the perspective of Walter School for Romania. That's what I can tell you right now. So that's a contractual undertaking. It's a commitment that will not disclose such information. Briefly, the solution uses Copilot, for instance, but it's a customized Copilot that Microsoft guaranteed by a contract that will not use in this way. We included it in a protected area to which we don't have access, so that that's both contractual and technical commitment that such sensitive data will be controlled. And the data is there, we'll not do anything with it. We'll work on it. We'll develop AI agents. That's the next version. If you allow me to add something about contracts, Microsoft has got platform contracts or framework contracts, and there's a contractual data protection amendment. That's a framework agreement through which Microsoft guarantees that everything observes the same rules, the suppliers and everything. When a tool is developed on my platform, those contractual clauses are observed by all the partners. Copilot is the AI tool which doesn't use data to make training. It doesn't share the data with the internet, and that's provided by the contract. So any tool developed on our platform observes the same rule. I don't know particularly about this tool, but if this tool is developed on the Microsoft platform, yes it is, then there's a contract by Microsoft, and any user guarantees and commits to do the same thing. I wasn't aware about this product, but Microsoft does guarantee the data will not be disclosed. If you allow me, I've got a question under the DORA regulation context to prevent IT&C incidents. What can you tell us about this obligation to report information which are uploaded and processed? On what servers will they be sent? And the Financial Supervision Authority surveils data processing. Who knows where this data is leading to, and who receives it? The subcontractors and the people processing it. For those who work in a different field, the DORA regulation is a new regulation specializing in the banking industry. Microsoft has a standalone contract to map such requirements. So we have a standalone contract, an appendix to our standard contracts, which map all the DORA requirements. All the DORA regulation requirements are being mapped for the financial and banking field, where all this is being guaranteed. When you use the Microsoft Cloud, it's the client's choice of what data centers will pick. They may pick the one in the Netherlands, in Poland, in Greece, wherever in the European Union. It's a drop-down list, and the IT colleague will pick himself in what data center in Europe will this data be stored and processed. For instance, if you like the northern countries, you can pick them. If you want to for the data to be processed in Germany, then pick Germany. It's your choice. All the requirements in the DORA regulation are being input in that document which maps the requirements from the financial and banking industry. We sign it and everything is guaranteed contractually according to the requirements. Your Microsoft partner may send a message and provide you with this contract which is available in the system and distributed to anyone in the industry. Thank you so much, Gabriela. Cristina, do you want to add anything else? No.
So I was just wondering if there are any other questions addressed for the discussion. We don't have too much time, but let's see also if there are any other questions that we might answer from you.
Gabriela, presupun că folosești.
Gabriela, I assume you use Copilot in your general counsel activity. Yes, we are client zero. We're the first ones to use them. What are the benefits for you as a GC for using such a technology? I'll answer your question by a statement which is a question on everybody's lips. Copilot will not take our jobs. Will you please be assured? This tool will not replace us. Copilot does lots of things, but the most important is that it can help us with the repetitive tasks. Because we need a summary. It was something pertaining to the AI. It would take hours to me. Depending on the prompt that we give, we had many pieces of information. I checked whether they were useful. But without Copilot, I would take 6 hours to do something. Now it only takes a few minutes. What helps us with the repetitive tasks, with the large volumes of tasks, if you get back from holiday and have 3,000 emails, you may, of course, read all of them, but would like to know very quickly what tasks you have, what is the most relevant and most urgent, and you'll ask Copilot to have top. For instance, you may have received for your information emails, but other emails as well requiring you to take action. Copilot will get you a summary of your job, and if I have an email, I'll ask Copilot where in that email there is something to do for me. So the AI will not replace us, will only help us with information gathering, and it's safe at the same time. It's important for you to understand that those AI tools provided by Microsoft are very, very safe. Thank you.
Any other question? Okay, so thank you to all our speakers for all these thoughts-provoking insights. Definitely thank you to all of you for your patience for today. and joining us in this conversation. Let's keep asking the hard questions, but also let's make sure that all the answers remain human, because at the end we are human beings, and I think it's very important to remain human in whatever we are doing as a daily business. Thank you very much once again, Wolters Kluwer Romania, for inviting us in a very interesting day. And let's hope all of you enjoy it, and all the best for everybody. Thank you.
Să coborâm aici?